I'm just a bill, yes, I'm only a bill. And if they vote for me on Capitol Hill, well then I'm off to the White House where I'll wait in a line with a lot of other bills for the president to sign. And if he signs me, then I'll be alone.
Okay, welcome back, folks. In our first video about Gundy versus United States, I told you a little bit about the debate going on between the majority and the thesis that it stated and the dissenting opinion. So let's actually get a little bit more into the debate about this decision by following our usual format, looking at the facts, at the law or legal issue presented, and at the rule that led to the holding. Okay, so the facts. The Sex Offender Registration and Notification Act, SORNA, was passed in 2006 to beef up requirements for sex offender reporting. Congress wanted a national list of all sex offenders convicted by the federal government or by the states, and it wanted to see to it that these offenders did in fact register in their local communities. The reason being so that other residents could know that they have a sex offender living down the block. And offenders had to do this for as long as was required by their sentences, sometimes 15 years, but it could go up to life depending upon what they were convicted of. By the 90s, many or most states had sex offender registration laws, but if an offender moved into another state, he might simply go undetected and evade the registration requirement in his new state. So that's one reason why the federal government thought that one list for the entire United States would have some effect. So, SORNA required all sex offenders to register and to update their registration whenever they moved under penalty of law. It tried to leave no loopholes as the old system had, so it required sex offenders to register before they were even released from prison and to continuously register as they updated their whereabouts. But this left some complicated problems which Congress discussed in their debates. There were many past offenders who simply couldn't comply with the register before you're released requirement because they had already been released. And those people might not know that they had to continuously update if the law previously had been a bit vague on what happens when you move to a new state. Even if they were trying to comply, this could be true. And well, I mean, Congress itself was admitting that the old law was vague and full of loopholes by making this new law. So it gives you a sense of how complicated compliance might have been for those folks convicted prior to the passage of the act. Okay, so what was the best way to enforce the registration requirement against past offenders? Enforcement mechanisms were clearly specified for all offenders to be released in the future, registration at the time of release, and continuous updating with punishments that were specified. But perhaps, Congress saw the question of past offenders as an enforcement problem that they could let the Attorney General solve. I say perhaps here because that's what's in dispute between the majority and the dissenters in Gundy. The majority thinks that Congress was simply leaving the Attorney General a little leeway to figure out enforcement, which, as part of the executive branch, is a proper role for the Attorney General. But the dissenters think Congress was giving the Attorney General the power to decide whether to even apply the statute to past offenders, and that would mean that the Attorney General was being allowed to remake the law in certain ways, which is a legislative power and not an executive one. So, the law or legal issue. Here is the clause in SORNA that is being debated. The Attorney General shall have the authority to specify the applicability of the requirements of this subchapter to sex offenders convicted before the enactment of this chapter, and to prescribe the rules for the registration of any sex offenders and for other categories of sex offenders who are unable to comply with subsection B. It's important to note here that subsection B is the subsection that required registration upon release for all current and future offenders, suggesting that perhaps this part of the law was only pointing to the pre-registration problem for past offenders and giving the Attorney General some discretion on dealing only with that problem. But I think you have to admit, as you're looking at this here, that this phrase in the law isn't very clearly written to say precisely that. The first part of the sentence seems as if it could say that the Attorney General has discretion to decide whether past offenders will register at all, because you see here it says that the Attorney General can do this and this, can specify the applicability and prescribe rules for the registration of past offenders. If that's two different things, then the specify the applicability clause might have a broader range of application than the later clause, which does more clearly only refer to past offenders. Okay, now the rule that leads to the holding in this case. The majority says on page 5 that Congress has done the work of legislating if they've given an intelligible principle to the president, and they've told her to execute decisions consistent with that principle. It's a low bar, admittedly. It basically only says that Congress has to simply state a purpose for its law, but they say that's what the court has always done with this rule, the intelligible principle rule, and they've done that basically to approve any delegation which satisfies this low bar. So to argue this, the majority elaborates upon a rule which is found in Mistretta versus United States, a 1989 case. That case decided that Congress may delegate if it gives, quote, an intelligible principle to which the person or body authorized to exercise the delegated authority is directed to conform. Here on page 5, they also talk about how they're going to justify their decision. And remember, that's really important to any legal thesis. They say this: the constitutional question is whether Congress has supplied an intelligible principle to guide the delegate's use of discretion, so the answer requires construing the challenged statute to figure out what task it delegates and what instructions it provides. So, what instructions does the law give? Well, the majority says on page 11 that the very first sentence of SORNA states the purpose, to protect the public, and it states a mechanism, a comprehensive national system for registration. And they then argue on page 14 that this gives the Attorney General very little leeway in the completion of his task. His task is to be comprehensive, so he must apply the law to offenders released before the act went into effect. So the majority say this: the phrase in the law, quote, specify the applicability, thus does not mean specify whether to apply SORNA, but, quote, specify how to apply SORNA to pre-act offenders if transitional difficulties require some delay. So now we see something that we didn't before in their thesis statement. We see that this sentence, right before you, this sentence from the thesis gives their reason why the non-delegation doctrine does not invalidate this act, SORNA. Under the act, the Attorney General must apply SORNA's registration requirements as soon as feasible to offenders convicted before the statute's enactment. The Attorney General must do this as soon as feasible, specifically to these people. The majority in Gundy says that thing to be done is well specified enough in the introduction to the law and in the rest of its, quote, intelligible principles to make a comprehensive registry to protect people. The two words out of the introduction to the law. The problem, they say, is one of execution. How to apply this law to a more complicated group, and the clear command is given to the Attorney General: you must do this soon. The court concludes that Congress handed over no legislative power to the AG, but properly asked him to execute Congress's will, not his own. But Justice Gorsuch replies that this neither uses the right rule to judge Congress's action, nor does it reach the right holding about SORNA itself. Gorsuch thinks that founders, like Madison, didn't want legislation to be as easy as stating a simple principle like protect the public. He says on page 7 of his dissent that the framers wanted the process of legislation to be, quote, arduous and to result in, quote, detailed rules. And they considered this a bulwark to liberty because it meant that Congress would have to work a lot more slowly to get agreement on lots of details and would therefore take more interest into account. And maybe, he thinks, make less law because of that, which he thinks would be a good thing, and he thinks the founders thought that would be a good thing. And not surprisingly, Gorsuch quotes both Hamilton's Federalist Papers and Madison's idea in number 51 that ambition must be made to counteract ambition. So think about what he says here on page 9 of his dissent and how it applies to the idea of the extensive republic and everything we learned about separation of powers in our institutions lectures. Take a look at this quote. Without the involvement of representatives from across the country or the demands of bicameralism and presentment, legislation would risk becoming nothing more than the will of the current president. And if laws could be simply declared by a single person, they would not be few in number, the product of widespread social consensus, likely to protect minority interests, or apt to provide stability and fair notice. So Gorsuch says that this is the work that Madison had wanted, to reach widespread consensus among lots of different interests across the extensive republic. And that, Gorsuch says, is why the court has applied more than just the intelligible principle rule. And in fact, he says, if you look at their decisions, the court has actually applied 3 rules. Take a look at them here. First, they've said that Congress must make the policy decision, leaving the executive only to fill up the details. Gorsuch says that on page 10 of his dissent, and he shows you the receipts there. Congress can delegate to the executive fact-finding when certain facts beyond their ability to ascertain are needed to execute the law. He says that's the second principle, talks about it on page 11, gives the citations for it there. And then the third principle is that Congress can assign non-legislative responsibilities to the executive, like deciding how to apply a law if unforeseen events occur in foreign affairs or in the military, both of which are largely presidential domains of power. Gorsuch talks about that on page 12 of his decision and gives the proper citations. So Gorsuch claims that lots of other justices have misunderstood the intelligible principle statements in the Hampton and Mistretta cases. He says these words were never meant to replace and therefore to significantly weaken the 3 traditional principles that I just outlined for you. So he claims on page 15 to 16 that those words were simply meant to sum up the first of these principles, that Congress has to make the policy decision and leave the executive only to execute its wishes in the right way, quote, filling up the details. He says that the intelligible principle doctrine was really only meant to state those things, the first rule. So, having stated a new set of rules, he applies the first rule to SORNA on pages 22 and 23, and he claims that by stating simply to protect the public by creating a registry, Congress avoided the necessary hard work of making the policy decision. It handed too much power to the executive. Now, people have objected to Gorsuch's argument. They've said that he ignores that SORNA was actually a 20-page law and that it said a lot more than just protect the public. It stated a lot of goals and gave real specifics about implementation, and perhaps it only left open the details of how to apply this to past offenders. At any rate, those are the competing positions on the non-delegation doctrine in the Gundy case. You've seen what, why, and how each side argues, with the disagreement being less about facts and law and more about the rules to apply and the holding to reach in this case. So now what I want you to do is actually write down your own thesis about this case. Think of it as a model exam answer if you want to. Keep it under 250 words and model it to a certain degree on the court's opening paragraph, but do more. First, choose which side you'll support. That's your client. Second, say what you're going to argue against the other side. They say this, I say that. And this requires you to acknowledge what they say, of course. Third, say why you're right, doing the best you can to show why the facts, law, and rule should be read in your way, not their way. Then fourth, say how you make your case, including giving a killer piece of evidence that shows that you're right on the facts, on the law, and on the rule to be applied. So the entire argument that you'd make about the case should be condensable to about 250 words, less than 2.5 minutes of spoken text. And I really do want you to write these down because we're going to talk about your argument in class. We'll pit some of you against each other if you have opposing arguments. We'll perhaps critique some of the written thesis statements that you've put down on paper. And we're going to get into a discussion about the Gundy case by way of these thesis statements. So I look forward to doing that with you, and I think it'll be fun. See you then.